You're tuning into the Real Estate Diversification Podcast, hosted by trusted and experienced real estate attorneys who are also seasoned real estate investors themselves. Are you ready to explore unique real estate investing opportunities? Ready to learn about emerging trends and new ideas? Your hosts will help you understand the practical and legal complexities of a myriad of real estate investments so that you can maximize your potential and achieve financial freedom. Now, listen in and get ready to learn.
Welcome back, Red Podcast Nation. The topic of this podcast is key lease provisions in office leasing. Recap a little bit about me. This is my second ever podcast. My name is Jay Heck. I'm a real estate lawyer with Kansas City Real Estate Law. I've done tens of millions of dollars in office leasing over a 25-year career. Seen lots of office leases, and we're just going to hit the high points today. We're going to basically, what I've done is transcribe some terms from an actual tenants form office lease. And you may ask, why in the world did you select a tenants form lease? If this is primarily catering to folks who want to invest in office properties, they're going to come at this from the landlord's perspective. And the reason why I decided to use a tenants lease as the basis of this podcast is that gives you an insight into what the tenant's looking for and things that you might not be anticipating as a landlord, but that the tenant definitely has on their mind when they go to negotiate a lease. Okay, starting off in your, and this is true for a lot of commercial leases, your office lease typically starts out with what's called the basic lease info. You might have a cover page and you might have a directory, but it starts out with the basic lease info. And it's usually some term that or something very similar. And it's basically an outline of the economic terms. And that's the first page or two. And it's just sort of bullet points. This will start out with, as I said, the economic terms. And then there'll be, things like tenant's address, landlord's address, what the rent is per month, per year, and might get into cost per square foot on triple nets, and we discussed those in the last podcast, and we'll touch on them again today. It'll tell you when the term starts, and the term may start effective the day that the lease is signed. When the rent starts, and the rent may start at a different date than when the lease starts. We'll tell you when the lease expires. So those, like say, just the basic outline of the economic terms, and then you get into the real legal meat of the lease. The lease that I reviewed before I did this podcast was 49 pages long, and that included exhibits. The actual lease itself was around 35 pages long, and then the rest of it was exhibits. And so there's lots of detail, and there's lots of things that are discussed, and there's negotiation can occur on almost every point in a commercial lease. So you never know exactly what to expect. I've been doing this for nearly 30 years, and I still get surprised with the requests that either tenants or landlords, depending on which side of the aisle that I'm working, ask for changes in lease documents. But this is a pretty common format. This lease is a standard office lease that was used by a very large commercial client. And I'm just going to basically follow the lease through the form and key off of that and use that to hit as I said, to hit the high points. The first provision lease, it'll describe the premises, which is the space that the tenant actually occupies. Then oftentimes it'll distinguish the premises from the building, which should be self-explanatory enough. And then sometimes it gives a definition of what the project is, and that's if the premises in the building are within a larger office development. There might be provisions that are applicable to the project, and this is something that anyone reviewing the lease needs to keep an eye on throughout the review, because sometimes people get those in their head. They think of them all as one thing. They're three distinct things, and a provision that very well should possibly apply to one of those components or subsets may not necessarily apply to the entire project or apply simply to the premises. And I'll try to come up with an example of that as we go along. In this particular lease, it talked about the rentable square feet, and most folks would just think, well, the rentable square feet is the square foot of the floor space inside the walls of the space that I'm going to occupy. And in fact, it came up in a lease negotiation I was working on just a week ago, and it was a different lease form. It was the landlord's lease, and it actually went into more detail about rentable square feet than I believe I've seen possibly ever. And it gave you the real definition of what the industry calls rentable square feet. Rentable square feet is not the same thing as the floor area of the space inside the tenant's four walls. It actually includes, in a way, the space within the common areas of the building. So the rentable square space, or rentable square feet, is the square feet in the entire building. And so if the building was 20,000 square feet, and 5,000 of the square feet is elevator lobbies, hallways, atriums, common area bathrooms, and things such as that, then the rentable square feet is the entire 20,000, and that gets a proportion of that equal to the ratio of the tenant space in the building actually gets included into the rent. That's called the load factor. So if in my example with 20,000 square feet and 5,000 square feet of common area space or non-usable space, if you think of it another way, then that would be, hold on, let me do my math. 5,000 out of 20,000 would be 25%. And so your load factor would be 1.25. So the landlord, when they're calculating rentable square feet, will take whatever the space is of the tenant, say it's 1,000 square feet. They're going to add onto that 1,000 square feet. They're going to multiply that times 1.25 so that your rentable square feet is not 1,000 square feet, it's 1,250 square feet. And this surprises a lot of tenants that bother to delve into this. And as I said, this lease actually went into great detail and explained all of this information about load factor, although I don't believe it actually used the term load factor, and laid it all out on the table, where typically it just says the rentable square feet of the premises is X. And most tenants just look at that and they don't know the distinction, and they just think, well, okay, that's the floor area inside my premises or inside my four walls, and so I'm comfortable paying that. And typically rent, or often anyway, rent is expressed in terms of rent per square foot. So if you're thinking that you've got 1,000 square feet and you're being billed for 1,250 square feet, obviously that's a huge premium or extra expense that you weren't perhaps counting on. Oftentimes tenants will then start to question what the number of square feet is. They remeasure the space and they say, aha, I've discovered that this isn't as big as what it is that you're charging me for. And that's when the discussion about what rentable square feet is. Rentable square feet is defined in certain codes, and that's usually the way it's referenced. It's rentable square feet under this such code. Common code is building owners, managers, and administrators code, and that's how they define this term, rentable square feet. So it actually became a question with this tenant who has leased office property before, but hadn't done it on a regular basis. And they were asking, what does this mean? They had to go through the definition of rentable square feet versus usable square feet. Okay. Often another term was in this lease. It talked about a construction period. Obviously, that's one of the, well, not obviously, but that's one of the ways you could tell that this was a tenant's lease. Oftentimes the tenant does not want to begin either leasing the space or paying rent on the space during their build-out period. So this, in this case, the rent did not commence, but the lease term did commence. So the other provisions of the lease, except rent, started when the lease was signed or when the tenant moved in, but the rent didn't start until some time after. And so if the tenant has to go in and work on the constructing all of their improvements, and we're talking alterations, additions, and improvements, we're not talking about moving in furniture or fixtures, then they want 90 to 120, sometimes a more complicated build, they want 180 days, where that's a pre-rent period. And like I say, all the other terms would apply. They need to observe the rules and regulations. They need to make sure that they have insurance before they move in, but they're allowed to go in and build out the space. The thought is they're not really using the space yet. It hasn't become a productive office space, but they don't believe they should be paying rent. It all comes out in the negotiations. That would be figured into the economic terms of the lease, whether or not there's a pre-rent period. And the landlord would just account for those terms, realizing that the tenant's rent will not start until 3, 4, 5, 6 months later. Another giveaway that this was a tenant's lease is it had an early termination clause. So the office leases are typically for 5 to 10 years. And this was I believe it was a 5-year term. It had provisions for multiple options for renewals, but it had a termination right at the end of the second year. So with some advance notice, at the end of the second year, the tenant could say, well, this hasn't been a successful location for us, or our business isn't doing as well as what we thought it would, or we can consolidate this location with another location that we have, or any number of reasons. They just simply give the landlord notice and they say, we're going to be moving out on this date, and they're able to because they pre-negotiated this provision. Obviously, if you're a landlord, you don't like the idea of early terminations, but if that's the only way to land the tenant, and you really are motivated to lease the space, you might agree to the landlord as an early termination provision. It's an unusual but not unheard of lease provision. Then the next provision in the lease we touched on was for options. And tenants often want options. Typically those give an advantage to the tenant. And I'll talk about that just a second. And then we'll talk about what the rent is for the options. So the rent for the initial term of the lease is generally set at the date that the lease is signed, right? It's this many dollars per square foot. And then we've got the triple net or pass-through provisions that the tenant will have to reimburse the landlord for. But it's typically set, although it might escalate a certain percentage each year, or escalate by consumer price index each year. And that consumer price index is a statistic compiled by the Department of Labor. There's many different iterations of it, but that you can easily look those up online and determine, and it tells you, it's basically a cost of living adjustment. And so it tells you in inflationary, high inflationary times, CPI goes up quickly. In low inflationary times, it goes up very little. Or sometimes you have, and this lease had a provision for it, a fair market value renewal rent. And so the rent would be determined at some future date based upon comparable space, leased to comparable tenants in comparable projects in nearby locations. And really, you don't know what that's going to be until you're several years down the road. But it on the face of it, it seems fair that both the landlord and tenant agree to renew at what the fair market rent is. This particular lease very wisely set out a process for determining the fair market value. And if you don't have a determinable process on fair market value, I've seen leases where they just simply say, well, we're going to renew at fair market value, and I, as the landlord, will tell the tenant what fair market value is, and then the tenant can decide to renew or not. Well, that's not an option, right? That's an agreement to agree at a later date, or actually what it allows is the tenant to tell the landlord to tell the tenant what the rent is at a later date. And if the tenant doesn't like it, the tenant can just leave. Well, the tenant has that right all of the time. So if you're going to do a renewal at fair market value, you want to make sure that there's a determination process, and this process this particular process was you would determine with each side would select a representative, typically an appraiser, to set the fair market value. And they would each have their determinations. The two appraisers would get together, and then it's either what we call baseball arbitration, which if they can't agree, then it's what we call baseball arbitration, and an arbitrator, a final third party, would pick from between the two estimates. And that encourages each side to be as reasonable as possible. If it was just simply, if it's just simply a third party will select between the two or set their own determination of what they believe fair market rent is, and then there's the incentive for each side to be unreasonable, hoping that they pull the rent more in their direction than the other party does in theirs. And so just know that if there's a fair market rent renewal rate, it needs to have a process set out that both sides agree to and that's reasonable. And then this particular lease, it said in it that it was a gross lease. The difference between a gross lease is basically with all services included, and the landlord bears all of the risks of the expenses going up. So the landlord pays the taxes, the landlord pays the insurance, landlord pays for the maintenance, and the tenant's rent is just one fixed amount, and either stays the same or escalates on a regular, generally an annual basis. And so the tenant knows going in with exact certainty what their rent is going to be. Tenants love that, right? Because it gives them ability to plan and their business, and the risk is shifted over to the landlord. On the other hand, the landlord would prefer to see an office lease or any commercial lease, and it's very common that it's what we call a net lease. And in a net lease, everything just shifts. The landlord gets an exact amount of rent from the tenant, and then in addition to that set amount or determinable amount, they get the tenant reimburses them for the taxes, for the insurance, and for the maintenance costs. And if those fluctuate, and if typically they increase, if they go up, then the tenant pays for that, and the tenant bears the risk. And then the landlord is absolutely certain of what their income stream is going to be on the property, because those other costs are passed through. And typically then there's variations on gross and net, which is usually either called modified gross or modified triple net. And net means insurance, taxes, maintenance. And so sometimes you'll see it expressed NNN or just called triple net. So as I say, the landlord likes that, landlord favors that. So the tenant needs to know, okay, what's going in there, what's included, what's not included, needs to be fairly detailed. Typically, the landlord is still charged with the structural maintenance of the building, the building envelope, and that would be the foundation, the walls, the floor slab, and the roof. And then there's often a debate on, is the landlord responsible for the roof membrane? So if the landlord has not the structure of the roof, so if it's a concrete building with a concrete roof, but then has rock and tar or has some sort of a fiber mat to seal out the elements, water and rain and snow, is the membrane reimbursable? Is that a pass-through cost if that's replaced by the tenant? So, and I'm of the opinion, or been of the school, at least in the past, where it's reasonable to expect the landlord to maintain the structure, but it's all something that can be negotiated. Like I say, you just need to make sure that you're aware of what is and what is not included in that lease rate. Then moving on, in this lease, it talked about utilities and services. It set out what services and utilities that the landlord's going to provide. Things things like electricity, and the electricity would typically be a pass-through, right? Even in residential properties, the tenants pay their own utilities. And however, the utilities might not be separately metered in an office property. In fact, often they're just collectively metered and at the building, and then the tenants are charged on a pro rata basis based on their percentage of occupancy of the building. So if your tenant occupied 10% of the building, they would just simply figure all of the utilities up and divide them by 10, and that would be the share that's passed through to the tenant. Oh, and I should say that all of these expenses are typically paid monthly, along with the rent, and often they're estimated at the beginning of the year, and the tenant pays 1/12 of the estimated cost, and then there's typically a true up or reconciliation process at the end of the year, where if there's an overage, the landlord refunds the money back to the tenant, and if there's a deficiency, the tenant is expected to make up the difference at the end of the year or at the beginning of the following year. Okay, repairs. This lease actually got into some detail about the repairs that the landlord was responsible for doing and repairs that the tenant was responsible for doing. And this goes back to this idea of repairing the structure, things that are capital expenditures, things like parking lot replacement, not sealing and restriping, but actually excavating the pavement and putting down new pavement. That would be classified as a capital expenditure. Likewise, replacing the roof is typically a capital expenditure. Repairing the foundation would be a capital expenditure. All of those things you could see could have enormous costs, right? And if they're just simply pass-throughs to the tenant could be hit with, a large bill that they weren't anticipating. Now, this particular lease, and it is common with a lot of leases, it says that if the landlord passes through those capital expenditures, which can be very large, that they would do so over the life expectancy of the capital improvement, and the tenant would only be responsible for their portion during their period of their occupancy or during their lease term. So, if I'm not sure off the top of my head what the life of, say, an elevator would be, but probably 20, 25 years, something like that. So if the landlord is going to, and I'm not, well, that's definitely a capital expenditure. It's not a structural element. But let's say they replaced the elevator and the lease was written in such a fashion that they could pass through that cost to the tenant. Then if it's got a 25-year life, that cost would be broken up into 25-year pieces. And if the tenant only had 3 years to run on their lease, they would only pay on their share. And if our example was they occupied 10% of the building, they would pay 10% of that cost divided by 25 years, but they would only pay that for the remaining 3 years of the term. And the idea would be a new tenant would come in and lease the same space, and then they would be there to pay that cost to the landlord. So the landlord doesn't need to try to collect it all today, and they don't need to necessarily collect it all from one tenant or just simply during the tenant's term. Interestingly enough, this is in a lease when we're talking about repairs, where we'd normally expect to see, if it's in the lease at all, what we call a tenant self-help remedy, and that you can probably figure out on your own. But the tenant often wants the right, if the landlord is responsible for making repairs and they haven't made repairs, particularly to the tenant's premises, and it's affecting the tenant's ability to operate, then the tenant wants the right, after notifying the landlord, that if the landlord refuses to act or simply doesn't act, that they can go in and then do those repairs. And then the real hammer on a self-help right is to have the right to offset the rent until they've recouped their costs. Now, this lease had this provision, but it wasn't in section 7 following the repairs section. It was in section 26. It's buried toward the end of the lease. And when the lawyer or expert or whoever's reviewing the lease is sort of losing their energy, trying to get through the lease, trying to finish up, and it's in a spot where they would not expect to see it. It throws their rhythm off, probably giving an advantage in this case to the tenant. This is a strategy that is used in leases and in negotiations, right? Just concede on certain things, and then skip over the thing that's most important to you. And the other side thinks, oh, well, we thought that was going to be a big issue. And then at the end, the party brings that up in the negotiations. And after they've received all of these concessions, because it looks like they're being reasonable and they didn't blow up about a provision that was almost certain to be controversial, they bring in this provision, and then now the party that they're negotiating with sort of regrets having given all these concessions, which is tough to draw back. But the other party has sandbagged them by omitting this important provision and saving it to the last. It's a negotiation strategy. Unfortunately, I've been on the receiving side of that often. So when I'm in lease negotiations, I say, well, here's the way we want to do this. We're going to go through this point by point, and if you don't raise it, then it's not part of the deal. And then warn them, like, don't be bringing points up at the end of the document after we've gone through everything and we've tried to be as reasonable and forgiving as we can and try to put a deal together just to save this up, particularly when it's almost always something unpleasant. Anyway, so you're getting a little bit of negotiations and provisions as well as lease provisions themselves today. Well, it looks like we've reached the time limit on this segment. We're going to pick this up in a second part. You can join me back for more key provisions of office leases, and we'll see you next time. Invest wisely. Thank you for watching the Red Podcast. Bye-bye.
Thanks for listening to the Real Estate Diversification Podcast. Did you enjoy the episode? Visit www.rediversification.com to tune in to more exciting episodes and free information and tools that will help you succeed. Leave us a review and subscribe to us on Apple Podcasts and our other social media channels at the RED Podcast. Thank you for listening, and we'll see you next time. Missouri Bar Advertising Disclosure. Neither the Supreme Court of Missouri nor the Missouri Bar reviews nor approves certifying organizations or specialist designations. The choice of a lawyer is an important decision and should not be based solely upon advertisements.